As it is the court, I to appear for the state with Advocate Barondeze.
As my Lord should please, my Lord, I appear for applicants 1, 2, and 3 as before.
May it please the court, my lord, I appear for applicant number 4 as before.
Yes, the court cases, my lordship, I appear on behalf of applicant 5 and 6 as before.
As my Lord pleases. Lord, I hope today is going to be a lot more expeditious than the last 2 days of cross-examination. And I'm certainly going to try. Morning, Mr. Kanyagela.
Morning.
On either the last Thursday of, sorry.
Mr. Kanyangala, my assistant just says, I need to remind you that you are still under oath when cross-examination continues.
Yes, my Lord, please. Mr. Kanyangela, you might remember we spent some time on the previous occasion when you were being asked questions by me on the affidavit you made on the 23rd of November in support of a warrant for Mr. Esau's arrest. You remember that?
Yes, I can still remember.
Yes. Now, just to remind you, can I ask you please to look at Mr. Shangalala's affidavit? I think you'll find that in the green file. And
I don't know, somebody just said to me, one of the court staff, why does counsel for the first and second applicant keep on referring to Mr. Shangala as Shangalala? So I said, I just got the ear got used to it.
I'm sorry, my lord. I seem to have an unconscious.
Yeah.
I apologize firstly to Mr. Shangala.
Yeah.
I apologize to him unreservedly. I apologize to you as well.
I also never picked it up until somebody raised it.
And I too didn't realize there is.
Yeah.
It's simply an unconscious thing.
Yeah. All right. Without interruption, we can continue.
Now, can I ask you to look at Mr. Shangala's affidavit, and you'll see back there is no connection between the two, between the articles and the arrest. And you said, well, it seems as if there was a mistake because you were using another affidavit. Remember your answer to that effect?
Yes, correct.
Okay. Now I want to take you then to the affidavit that you made when you applied for a search and seizure of certain premises. You remember that affidavit? Or well, you remember that procedure, the application for the warrant, for the search and seizure warrant?
Yes, I remember.
Okay. I'm going to, Mr. Kanyangela, show you, and my lord, I've given copies to my learned friends. May I hand up a copy?
Yes.
Lord, the basis on which this is asked to be admitted, my lord, is that it is a previous statement made by this witness in regard to a matter of interest in this application because it concerns the same accused effectively collectively.
Yeah.
I've given my learned friends notice of this. Lord, may I ask that I be given leave to hand up a copy to the witness? Now, Mr. Shangalala, this is, you'll see a document in effectively two parts. The first 2 pages constitute the search warrant, and then the rest of the pages constitute the affidavit. You agree?
Yes.
Okay. I'll take you through that in a moment. Lord, I would ask for this to be admitted as part of the bail record, my lord. We were last on Exhibit Z. Lord,
Yeah, that's why I say I was working on the statement,
yes.
which probably will be this one for
Yes.
the search. And that is why paragraph 16 was not deleted from there.
17, you mean? Oh, I see. 16 years. No, I
Yes.
understand. Yes. Okay. But you accept the fact that I'm saying the text is exactly the same.
Yes.
Okay. Now, what I wanted to ask you, though, is this. If you look at the first premises identified, you'll see that that's Earth 91 of Papagean Street. You see that?
Yes.
Okay. Now, can I ask you then to turn to the first 2 pages of AA, and that's the search warrant that was granted. And you'll see on page 2 of the search warrant itself, in paragraph B, on page 2, the warrant says, it appears to me, starting at page 1, on reasonable grounds for believing that, and B says, there is upon or under the control of any person at the premises of 91 these various documents. So what I'm saying is this warrant is in respect of Earth 91. Would that be correct?
Yes, correct.
Now, that warrant was granted on the 23rd of November, is that right? You'll see that
Yes,
at
correct.
the bottom of page 2.
Yes, correct.
And you then say in your affidavit, and can I take you to that part of your affidavit, paragraph 17, which says, I therefore apply in terms of 22.4 for the issuing of a warrant.
Yes.
Right. So you made that application, right?
Yes.
Now, just in terms of procedure, did you go to the magistrate with your affidavit for the search and seizure warrant?
No, I did not go there self. I think my statement was given to Mr. Klute to go and apply to take it to the prosecutor.
So it's the prosecutor who applied.
Yes.
Because, and I'm looking at procedure, I'm not saying there's anything wrong with it. Can I just say to you that if you look at paragraph 68 of Mr. Shangala's affidavit, or the annexure to Mr. Shangala's affidavit, you'll see there, and that I pointed out already to you, that the prosecutor actually makes a formal application for the arrest warrant, which is then granted by the magistrate.
Yes.
Now, in the court papers, and that doesn't mean that this wasn't there, this application by the prosecutor is not there. I'm not saying therefore it wasn't there. I'm just saying that's how the court papers are. This affidavit was uplifted from the court papers in the SO application.
That was for the search warrant? This document that you are referring to?
Mr. Shangalala, perhaps we're talking past each other. I mean, Mr. Kanyangela, we're talking past each other. I'm saying to you, if you look at SCS 3, page 68, you'll see that there is a formal application by the prosecutor.
Yes.
Was there such an application in this case? Do you know or do you not know?
What I know is only that my statement was taken to the prosecutor for him to apply.
So you don't, it was just taken by Mr. Klute,
Yes.
and the next thing is this warrant was granted.
The warrant of arrest.
No, the warrant of the search warrant now.
You are referring to page 68, which is a warrant of arrest.
No. I'm referring now to the search warrant, the search and seizure warrant. I'm saying in those court papers, there isn't a similar document as is contained at page 68.
No, there is no.
There is not.
What is there is only the search warrant.
Okay. But you didn't go to the magistrate.
I self did not go there.
Okay. But the magistrate issued the search warrant. We know because he signed at the bottom.
Yes.
All right. And that's on the 23rd of November.
That's correct.
Now, can I ask you then that that's the same day that the arrest warrant was signed, if you look at page 68, the bottom of page 68.
Yes.
And you'll see that the signature of the magistrate is the same.
Yes.
Do you know whether the application was made at the same time, the application for the search and seizure and the application for the search warrant? Or do you not know?
It was made at the same time.
So the prosecutor went to the magistrate for both warrants, and the magistrate issued both warrants.
That's correct.
And one after the other. The same prosecutor approached him for two warrants on one occasion.
That's correct.
How do you know that?
Why I said they were issued on the same day, because my statement for the search warrant, I compiled it on the 22nd of November. For the warrant of arrest, I compiled it on the 23rd. And both statements were given to Mr. Klute to take them to the prosecutor on the 23rd.
You heard my question, Mr. Kanyangela?
I heard your question.
The question is, how do you know that that the prosecutor on the same occasion applied for both warrants? That is the question.
Because they were issued on the same date.
That's your answer.
Yes.
Now, you made an affidavit based on these two, the documents we've now been discussing.
Yes.
The two applications for the warrants. You made an application on the you made an affidavit on the 22nd for the search and seizure warrant.
Yes, correct.
Right. But that application was made on the 23rd to the magistrate.
That's correct.
Now, on the 23rd then, you made an affidavit in support of an application for their arrest, and we've been through that already.
Yes.
That was a Saturday.
Yes.
Something must have happened between the Friday, the 22nd, and the 23rd for you to require a warrant of arrest. I'm putting that to you.
There was nothing happened that I can recall.
Really? Really? So, Mr. Kanyangela, at the risk of incurring the wrath of my learned friends that I'm arguing the matter with you. I'm going to put this proposition to you. You may answer if you want or refuse to answer if you don't want. But this is the proposition I'm going to put to you. And I'm going to put them in parts. The first proposition I'm going to put to you is that comparing an application for search and seizure and an application for an arrest, an application for an arrest is more invasive of rights of individuals. So that's the first proposition I want to put to you. You want to comment on that?
It was not an invasive of somebody's right.
Okay. That's your answer.
Yes.
The second proposition I want to put to you is, on a Friday, you apply for a search and seizure warrant. And then at 9:30 on the Saturday, you apply for an arrest warrant. I'm suggesting to you that something happened between the two. You say nothing happened.
I cannot recall if something happened. It's only that we wanted the arrest and the search to be done at the same time. Hence, we apply for the warrant of arrest and the search warrant at the same time also.
No, Mr. Shangalala. You made your affidavits on 2 separate days.
Okay, Mr. Kanyangira.
Oh, stop being petty, please.
No, but that is not Mr. Shangala.
Mr. Kanyangela, can I ask you, you made the affidavits on separate days, is that right?
That's correct.
So it was not made on the same, the application was made on the same day, but the affidavits were not filed on, made on the same day.
No, they were not made on the same day.
So I'm asking you what happened between the time you made your affidavit on the 22nd and the time you made your application on the 23rd.
I cannot recall something happened.
I'm suggesting to you for, I don't know how, the umpteenth time that you are being disingenuous. You are holding back something, and it is going to redound on your credibility at some stage.
Objection, Your Lordship. This is, as I indicated before, I've objected this line of cross-examination before it's being argumentative. If he's having instructions or he knows what happens, then it must be put to the witness for the witness to answer, because the court wants to deal with the facts, as the court indicated before, not speculation, as it pleases the court, Your Lordship.
What is it that you want me to do now?
Your Lordship?
No, you are making a statement. You say objection,
Yes.
but you are not telling me what you are objecting to.
To the line of cross-examination where speculation is being put to the witness that something might have happened, but nothing is being put to this witness that this is what happened. Now the witness is expected to answer to that something that might have happened, which we do not have before court.
Yes, I can't tell counsel what to. If he says he knows something must have happened, he puts it. If the witness says nothing has happened, he is saying he's going to argue.
Yes.
So what must I do? I'll wait for the arguments.
The issue, Your Lordship, is that he's not putting it to him. He says something might have happened, but what is that something? So, at the end of the day, Your Lordship, what the state wants to put across the court is that if there are no instructions as to what in actual fact happened, then they should not speculate that something might have happened and you are being disingenuous or you are not being truthful because something might have happened. So really, we submit, Your Lordship, that should not be put to the witness, and he should stop calling the witness's name, because at the end of the day, before the court to decide whether this witness is being truthful or untruthful, as it pleases the court, Your Lordship.
The way I understand, he says he's going to argue it. If he's going to argue it, I can't stop him.
But at the end of the day, then he should also not call the witnesses' names, really. Say you are being untruthful, you are being disingenuous.
Okay, Mr. Sonny.
Perhaps my learned friend should listen to the question. It will be helpful. Lord, may I make this point? Your Lordship will recall that this matter was debated, and it's now accepted law in Southern Africa, in the Safu case, where a judge said to President Mandela, or made a finding that President Mandela had lied. And when the matter went to the Constitutional Court, the court unanimously said, when you put a proposition like that to the judge, you must put it to the witness so that he can respond to that. Now that's exactly what I am doing. I'm giving him an opportunity to say, I am going to say to your Lordship that you are being disingenuous. Now, I did not, so my learned friend is wrong, and completely wrong, my Lord, when he says I am speculating. Lord, one of the purposes of cross-examination is to test what the witness says against objective facts. And then, of course, we won't know if a witness is lying, but courts look at what is it that objectively happened, what did the witness do. If a proposition is made, the witness must be lying. Is there force in that proposition? Now that's the proposition. I put not might have happened. I said must have happened. And that I will argue again, my Lord. But the proposition I am putting is not speculation. I am saying, my Lord, that given the way that one would expect the difference between a warrant of arrest as opposed to a warrant for search and seizure, that the one is more invasive than the other, that one would expect that more thought would be given to it, and that the application for the warrant was decided upon on the 22nd, and then the application, the warrant for the search and seizure warrant was on the 22nd, and the arrest warrant was the 23rd. And I'm entitled to say something must have happened. And my Lord, it is not without context. Your Lordship will recall how much of time it took to extract from this witness that he had discussed the question of the arrest with Advocate van der Merwe 2 days before the application was made. It took about 45 minutes of cross-examination on that issue. That's the context, my Lord. So the submission, my Lord, is there is no merit at all in the objection, and with respect, your Lordship should overrule it.
Yes. Objection overruled.
As my Lord pleases.
Okay. Proceed.
As my Lord pleases. Now, on the last occasion, you said, and you'll remember this, that in regard to the arrest warrant, you had discussed it with Advocate van der Merwe about 2 days before the 23rd. You remember that evidence?
Yes, I remember.
Did you discuss the application for the search and seizure with her as well?
Yes.
Now, the question I want to ask you is, and of course it's nothing more than an intriguing thing. There was a great deal of time spent on that issue, on did you discuss it. Why didn't you tell his Lordship on that occasion? Well, my Lord, forget discussing the application for the arrest. We also discussed the application for the search and seizure.
I did not bring it to the attention because this search warrant was not presented to me on that particular day, like you presented today.
Yes. Okay.
And what I said, your questions were based on the search warrant, on the warrant of arrest. You asked whether we discuss it, of which I have confirmed. And that does not mean that that is the only thing that we are discussing.
Yes. That's your answer.
Yes.
And I'm going to say to you, I will repeat now, that you have not been forthcoming with the actual facts relating to these warrants. Now, let's forget that for a moment. You know that the warrants themselves, the search and seizure warrants, were the subject of a court application.
The search warrants.
The search and seizure warrants, yes.
I cannot recall whether it was
Cannot,
also
eh?
part.
Well, there is a case decided by Mr. Justice Masuku in which you are the fourth respondent. You cannot recall that?
I can recall the application.
Yes. But you can't recall the case. I sigh again, Mr. Kanyangela, because you are one of the respondents in the case, and you say, I can't remember the case. Really?
Well, I can remember the case, but I cannot remember the content of the statement that you are referring to.
You remember the case
all
now?
All of the content.
You remember the case?
Yes.
Okay. I want to say to you, my Lord, I'm referring to the judgment of His Lordship, Mr. Justice Masuku, in the matter of Esau and others versus the Director General of the Anti-Corruption Commission and others. It is cited as case number HC-MD-Civ-MOT-General, and it's reported at 2020 case number 4, and the neutral citation is said to be Esau versus the Director General of the Anti-Corruption Unit, and it's 2020 of the decision of the High Court 59. That's the new 59.
Yeah, the date of delivery.
Oh, sorry, 21st of February 2020, my Lord. Just want to, this is a reported case. I just want to ask you, in relation to the warrants, when they were being executed, were you present? In other words, when the searches were in respect of these warrants?
I was not present.
You were not present at all?
No.
Okay, I just wanted, but who executed the warrant? In other words, who took the documents and things that are cited in the various warrants that were issued?
I can only recall that Mr. Oliphant was in charge of that search, but and he was accompanied by some police officers. So only that I cannot say now who are the police officers, but Mr. Oliphant was in charge of that search.
Okay.
So he went there with some police officers
Now,
and some ACC officials.
Sorry. Okay. Now, you read the judgment, Judge Masuku's judgment.
Yeah, I read it.
Okay, I want to remind you of what he said. At paragraph 105 of the judgment, the learned judge says, and I want you to comment on this. The first and second applicants in that application to set aside the warrants, and I've got to place on record, my Lord, the warrants were not set aside, but the learned judge made some comments about how the ACC had conducted itself. And that's what I want to put to the witness. At page 105, paragraph 105 of the judgment, the learned judge says, the first and second applicants, who are Mr. Esau and Mr. Shangala, also complained about being abducted. The word abducted is used in inverted commas by the ACC officers and forced to attend a search at their respective properties. Were you present when this happened?
I was not present.
Okay. Now you see, the learned judge says the ACC officers, which means it was besides Mr. Olivier, there were other ACC officers.
Yes, that's correct.
But you were not present.
No, I was not present.
Okay. Now, you were in charge of this, of the investigations, and I take it overseeing all aspects relating to the execution of the warrants.
Not necessarily to say I must follow the investigators everywhere they are going for investigation or to conduct a search. It's only that I was in charge of the docket. Whatever they are doing, statement they obtain, they bring them to me. I put them on the case file. Then I give instruction where necessary what is to be done again. Not to say that I have to follow them everywhere they are going.
Yes. But you read the judgment, though.
Yes, I read it.
Okay, so let me continue with what the learned judge says at paragraph 105. In this regard, this is being the abduction, the applicants wrote and signed documents in which they waived their rights to be present during the proposed search. The ACC officers, after an agreement was reached between the applicant's lawyers and a senior official at the ACC to allow them their wish not to travel, having waived their right to be present during the search, nevertheless took the applicants against their will to the properties in question. And that's what the learned judge says was the case. Did you investigate that?
No, I'm not aware of any abduction. That's why I did not investigate anything.
So you didn't believe what the learned judge found?
I'm not aware of any abduction because it was never reported to me.
See, I tell you what is worrisome, Mr. Kanyangela, is a judge of the High Court raises this matter. You are in charge of the investigations, and I know you've explained your role. You don't go around checking what they are doing. But when a judge makes a comment like that, is it not your responsibility as a constitutional body, and we've been through that, to say, but how can we act in a manner that a judge finds unacceptable?
I did not investigate such,
Okay.
but I am aware of the letter that Mr. Shahnara wrote, where they give these ACC officials permission to search their places.
Okay, you know my question is a different question.
Yes.
Let me tell you what the learned judge says in the next paragraph. The learned judge says, I am of the view that persons who have been charged with offences, regardless of the seriousness thereof alleged, are not only bearers of rights to dignity, but they also enjoy the right to presumption of innocence. That's a statement of the law. Then he goes on to say, the behavior by the officers from the ACC in this regard is despicable. Did you read that?
Yeah, I might have read it.
You might have read it.
Yes.
Mr. Kanyangela, are you serious?
My Lord, this statement that you were just busy with it. It was never served to me. I just read it maybe somewhere, somehow. And I did not really study everything that is in that statement.
Sorry,
I know I read it, but to say I have studied, understand it fully, that I did not.
sorry, when you talk about statement, are you talking about the document I've just been reading from?
Yes, the
Now,
judgment.
Mr. Kanyangela, I'm afraid that what you have just said is most worrying. And I say this because this is a judge of the High Court who issues orders and comments upon the conduct of different branches of government, whether it's the legislature or the executive. Now, he's commented about your unit. He's used the word despicable, and you call it a statement.
Sorry if that is.
Are you apologizing to me or to the learned judge? You did say sorry, didn't you?
Yes, I did sorry if I call it what is not supposed to be called.
But whom are you
By
apologizing
referring to
to?
it as a statement.
But whom are you apologizing to?
To the judge and to you.
Which judge?
The one who made the judgment.
And what about the judge presiding?
Sorry, my lord, for such comment.
Okay. Now, can I just ask you, when Mr. Becker left, as I understand it, it was around July 2019, you took over this investigation, is that right?
That's correct.
I'm going to come back to how it came about that it is you who took over. But let's leave that for a moment. What was Mr. Becker's role in this investigation thereafter?
I know the role he played thereafter. He was the one who charged the accused persons. He obtained their warning statements. I think that is mostly the role he played.
The only role. The only role.
That's the role I can remember.
You can remember, yes. Now, can I ask you, you recall that on the 28th of November, some of the accused applied for bail. 28th of November 2019.
I cannot recall that.
You cannot. Were you not present at the bail application on the 28th of
Probably not.
November?
No.
You were the investigating officer, but you were not present.
No, I was not present.
You sure?
Yes.
I'll tell you why. Because on that occasion, according to a judgment of His Lordship Mr. Justice Parker, there was supposed to be a bail application, but that application didn't take place. Are you aware of that?
Yes, I'm aware of that.
But you were not present on that day.
I was not present, my lord.
So, from the point, if there was going to be a bail application and it was going to proceed, I take it as the investigating officer, you would be present.
Not necessarily to be present there.
Okay. You're not interested in what happens to the arrest that you effected on the 27th of November, pursuant to the warrant that you secured.
Now, if there's somebody to testify or to go for bail application, it's not really necessary that all the investigators have to come and attend the bail application.
Yeah, we're not talking about all the investigators. We are talking about the chief investigator, as you described yourself, Mr.
Yeah, but
Commander.
anybody who is investigating the matter can come and oppose bail.
But you remember when we dealt with this matter, I said to you, on all the occasions that this matter came in court, you were the state's main witness. Remember that?
Yes, I remember.
Now, why I want to put this to you is, my Lord, this is a judgment of His Lordship, Mr. Justice Parker. I'm not going to deal with the papers, but there is something of significance in this. It's case number High Court MD CIV MOT Gen 2021-71, my Lord. And it was delivered on the 23rd of June 2021. There doesn't seem to be a neutral citation for this, my Lord. If your Lordship would require, I would make a copy of it available. Oh, but I beg your pardon, my Lord. The neutral citation is Helens versus the Minister of Home Affairs and others. The neutral citation is 2021, case number 300. It's delivered on the 23rd of June 2021. Now,
it should also be placed on record that this particular judgment being referred to is the subject of an appeal before the Supreme Court, Your Lordship. It has been appealed against.
Helen versus?
I think it's the Minister of Safety and Security, but here's a full citation. I do not have it with me. I just know it's appealed against Your Lordship.
It depends on what the statement is.
The judgment.
Yeah, no, what Mr. Sony said, there is a specific statement that he wants. So that statement, what is maybe appealed against is the ratio decidendi. Let's maybe first listen to what the statement is, and then, but I'm indebted that you have alerted me to the fact that it's appealed against.
As it were the Court of Lordship.
Yes.
Lord, I must confess I was not aware, but at the end of the day, until it is set aside, it remains good law. But I don't, as your Lordship pointed out, there would be a difference between what the learned judge said during the course of the judgment and the decision he made. I do not intend referring to the decision, my Lord, just referring to an issue I raised about Mr. Becker. This is what the learned judge says at paragraph 6 of his judgment. It says, on the day the hearing was supposed to take place, and remember I said supposed to take place, because bail applications, you know, are urgent. And he says, from the morning of that fateful and critical date, the 28th of November, the plot thickens ominously for applicants. And the applicants are Mr. Helens and Mr. Joubert, who are senior counsel from South Africa. Learned judge continues, while waiting in court for the bail application to commence, the prosecutor and a Mr. Becker, who described himself as a commissioner of the Criminal Investigation Directorate of the Namibian Police, arrived together at the court. Mr. Becker asked the first applicants, that Mr. Helens, to step outside, where he introduced a certain Mr. Imwala. From the papers, it is apparent that Mr. Imwala is an immigration officer. He is the third respondent. After a short exchange, Mr. Imwala confiscated the applicant's passport passports and arrested the applicants without a warrant. Are you aware of that development?
Yes, I'm aware of it.
So remember I asked you what role did Mr. Becker play? And you said no, you just took warning statements.
But that was not related to this case. It was not in this case.
Was it not the
That
bail
was on the
application?
immigration issue, where he arrested those people.
At the bail application.
It was a first appearance. I don't know whether it was a bail application.
Well, so you're saying, are you saying again, you accept now this is a judgment, not a statement?
Yes.
Are you saying again that the learned judge is wrong when he says it was to be a bail application?
Myself, I know that it was a first appearance of the accused people.
So,
But if it was for bail application, I will accept it as it is.
were you aware that Mr. Baker was going to be in court?
I'm not aware of that.
No, I'm not asking, are you aware? I said, were you aware at the time, on the 28th of November?
I was not aware.
Were you surprised that this had happened? That the counsel of the accused, who had come especially for whatever purpose, were arrested in court? Were you surprised at that?
I was not surprised, as I don't know how it came about for them to be arrested.
Did you raise it with Mr. Baker?
Your Lordship, I think it's not a correct statement that they were arrested in court. That is not where the arrest took place.
Sorry?
The arrest did not take place in court, as alleged, has put to the witness.
Is it in court or at court?
He said in court.
I heard at court.
I heard in court, Your
Oh,
Lordship.
okay.
Lord, it's quite clear it's at court, my Lord. And
what I hear.
I've got to say, my Lord, and it worries me tremendously that when one has a constitution like we have in Namibia, my learned friends and the witness who exercise such draconian powers can play around with the fact that something happens outside the court door as opposed to inside court. When you got two officers, we're not talking about just general people. We are talking about officers of the court. And my Lord, may I make this point, and I didn't want to go beyond this. They had been given permission by the Chief Justice to act in this matter, my Lord. Mr. Helens and Mr. Joubert. They had been given permission. It's in the judgment. I just make the point, my Lord, that my learned friends must take the Constitution more seriously, my Lord. And that's what this case is. That's what this bail application is partly about. The protection of the constitutional rights of the subjects of the Namibian government. Now, you didn't check with Mr. Baker after you read about this. How did that come about?
No, I did not.
You feel comfortable that that happened? That the accused were, for whatever purpose they were to be in court on that day, were to be deprived of legal representation?
Yes, I have said, I don't know how it came for them to be arrested.
And you know that in terms of the Namibian Constitution, it's part of the right to a fair trial for the accused to be represented by lawyers of their choice.
Yes, correct.
Didn't worry you though, hey? You want to answer that?
Maybe you can refrain. Ask again your question. I did not catch it.
I say it didn't worry you that Mr. Becker's intervention, according to the learned judge's judgment, is what effectively was the first step in their being prevented from representing the accused.
Yeah, sometimes it's worrisome, but as I said, I don't know what have prompted them for them to be arrested.
Mr. Kanyangela, can I just say, I just get the impression, I just ask for your comment because it's just struck me now, that there are a number of things that appear to have gone wrong. And let me just start right at the beginning. You applied in terms of Section 43 for the warrant on the 23rd, the warrant of arrest on the 23rd. You then accepted on the last occasions you gave evidence that that was a mistake. But a Section 43 application was made, except that you were not the applicant. Then what Judge Masuku says, then what Judge Parker says. Now, I get the impression that all of these comments about the violation of rights don't seem to affect you at all. Or they don't seem to be of any concern to you at all. You want to comment on that?
I don't want to comment on it.
Right. Now, this is the last topic that I want to cover relating to the preliminary issues. Now, after Mr. Becker left, as I understood your evidence, and you must correct me if I'm wrong, you took over the investigation. Is that correct?
I became a lead investigator because by that time Mr. Becker was having Clute and Oliphil, of which he was working on the case. And when they started with this investigation, I was not here at the headquarters. I was deployed at the Choarongo office. So I just came as a lead investigator on the matter.
You heard my question, Mr. Kanyangela.
Yes, I hear your question.
My question was, you took over effectively leading the investigation,
That's correct.
a task which had been performed up to then by Mr. Becker.
That's correct.
You took over despite the fact that Mr. Olivier and Mr. Cooper, Mr. Clute had been involved in the investigations with Mr. Becker.
Yes, I took over because of the position I held.
Yes.
I'm having.
But you were from a region outside Windhoek, is that correct?
That's correct.
What region is that?
So it was on Drupa region.
Sorry?
It was on Drupa region.
Drupa.
It was on Drupa.
Now, Becker's position at the time he left, and two things happened at the time he left. One is you took over the investigations, you were the lead investigator, and Mr. Becker left the ACC, is that correct?
That's correct.
Now, what was, is it correct that his position was Chief Investigations and Prosecutions at the ACC?
That's correct.
Now, you took over the investigation, you were the lead investigator, a task that had been performed by Becker previously. That's right?
Yeah, with regarding to this case here.
Yeah, sorry, with regard to this case, no, I apologize. That is correct, yes. But you were not appointed to the position he had occupied, namely Chief Investigations and Prosecutions at the ACC.
No.
Okay. Now, has anybody been appointed to that position?
It is still vacant.
This is from July 2019.
That's correct.
Now, it is correct that there's a dispute about that, who should occupy that position, isn't it?
Objection, Your Lordship. Relevance.
Lord, one of the things that I've been preparing in my cross-examination is that the decisions, and it comes back, my Lord, to this very issue. Because my learned friend says, I speculate between, when I say, well, what happened between the 22nd and the 23rd between the two applications. Now, my Lord, one of the issues I've been testing throughout was who has made the decisions in this matter. And this witness has given evidence as to the different people he's spoken to. The only person that he says he took advice from was Advocate van der Merwe, your Lordship will remember from the previous occasion. So this line of questioning, my Lord, is related to the integrity and the truthfulness of that evidence, my Lord.
Objection overruled. You may proceed.
As my Lord, please. Now, it is correct that there is a dispute about who should occupy that position, isn't it?
Yes, that's correct.
Okay. In the meantime, as I understand it, the position is occupied by a person who holds an acting position.
That's correct.
And that person is Ms. Justine Kanyangela.
That's correct.
She is the acting chief investigations and prosecutions at the ACC.
That's correct.
She's your wife.
That's correct.
So effectively, she is your superior.
That's correct.
You report to her.
Yes.
She supervises you.
Yes.
Why didn't you tell us this all this time?
Why should they tell?
Because, Mr. Kanyangela, though I don't normally answer questions, that's your job. Your job
Really,
is to tell the truth, sir. So I'm now going to go back to some of those questions, but we've been through that. It's all on record. So when a decision was taken to apply for the search warrants, and you made your affidavit on the 22nd of November 2019, did you tell your wife that?
My wife, she's part of the ACC investigators. In this case, we have always discussing it. But to say that when I make a decision was taken for the arrest or for the search. She was aware of all this as part of the investigators.
I'm asking a different question. Mr. Klute was aware. Mr. Olivier was aware. I'm asking a different question.
Yes, she was also aware.
Did you discuss with her the propriety, the lawfulness, and the desirability of applying for these warrants, both first of the search and seizure and then the arrest?
That one I did not discuss with her. That's why I say we discussed with the legal person who is the advocate.
Did you deliberately exclude your wife from that discussion?
I don't think there was any need for her to.
No, I'm asking a different question. Did you deliberately exclude her?
It was not deliberately.
Now, you, as I understand it, and you've made that concession, she supervised your work. You went above her to Mrs. van der Merwe, but didn't ask her or didn't tell her, look, this is what I'm going to do. What do you think?
As I said, she used to be part of the investigation team.
So you did discuss it with her?
But not with him, just us two or whatever.
And at
As
home?
I said, we used to discuss this case during our meetings with all investigators, because we normally give them tasks to go and do.
Including your wife. Your wife, now we know, was present at those meetings.
We have to have staff meetings, and she's the head. She's the one who's chairing the meetings.
You see, Mr. Kanyangela, the importance of what you are saying is this. I asked you on the previous occasion, who all were at the meeting? The people you mentioned were Mr. Klute and Mr. Olivier. You never mentioned your wife. Then when it was probed, you mentioned Mrs. van der Merwe.
I have referred to staff meetings and the meetings that we held with the advocate.
Lord, may I just conclude this part so that your Lordship is not in the dark as to why this set of questions has been raised, my Lord. Lord, the Supreme Court of Appeal, the Supreme Court, on the 4th of February, my Lord, handed down judgment in the matter of Masule against the Prime Minister of Namibia, a number of other people, including Mrs. Kanyangela, who is cited as the 9th respondent. That case, my Lord, is...
I'm aware of the case.
Oh, you're aware, as my Lord. My Lord, I became aware of the case after the previous session, and that's why I am only probing it now. I would have probed it on the previous occasion. But it's clear when one reads the judgment and the nature of the evidence given, of the relevance of these matters that I have raised with the witness. Now, Mr. Kanyangela, you're aware that following the arrest of the accused, about 1 year after they were arrested, there was an application to this court for a restraint order which has the effect of depriving all the accused in this matter, plus certain other people, of dealing with their assets.
Yes.
And you're aware that that application was made by the Prosecutor General.
Yes, I'm aware.
And you filed a fairly lengthy affidavit in support of that application.
That's correct.
Can we take it, and my Lord, I just make the point that in his affidavit in this bail application, Mr. Shangala raises the fact that the affidavit of the Prosecutor General and the witness would be used in support of this bail application, not in support, my Lord, but reference will be made to it. And that's the only reason I'm raising it. I need to say, my Lord, though, that given the evidence of this witness as to the role of the police, I'm limiting my cross-examination, so I'm just going to put to this witness what is said in that affidavit rather than going through the affidavit in any detail. So, Mr. Kanyangela, would I be correct in saying in that affidavit you set out the role that the ACC had played in the investigations that have led to the criminal prosecution of the accused?
Yes.
And I'm going to put to you, and you can comment if you want because it's there, that the role of the police, the Namibian police, is very limited. And if there is any other role, it is simply, as you said, taking statements and assisting in executing search and seizure warrants.
I have
correct?
already testified on that one, so I don't need to repeat it.
Now, I've put a proposition to you. I'm saying to you, do you agree or not?
I stick to that testimony that I just given.
Yes.
The evidence.
And I'm saying that that's what that testimony showed as well. You accept that?
Yes.
Now, I ask you please to look at Mr. Shangala's affidavit again, please. And can I ask you to please turn to pages 28, or to page 28, and I'll just refer you to any other page that I want. Now, in starting at paragraph 52 on page 28 of the affidavit, going up to paragraph 62 on page 32 of the affidavit, Mr. Shangala contends or sets out the reason for his contention that the investigation insofar as poker-created offences are concerned, that those investigations, as contained in your evidence, as contained in the affidavits in the restraint application, are unlawful. That's, I'm just orienting you to that.
They are not unlawful.
Yes, no, I know. I'm going to, I want to cut through because I know your position. I'm just going to ask you some questions and you answer as long or as short as you want. The thrust of what Mr. Shangala says in paragraphs 52 to 62 is the following. In terms of section 83 of POCA, before there is an investigation into poker-created offences, or the poker-created offences of money laundering and racketeering, the Inspector General of Police must authorize the investigation. Now, I'm just putting to you what his argument is. You can respond at the end, or you can respond with each proposition I make. Do you agree with that proposition? It's a matter of law, but you may say what you want on it.
I agree with the section of the POCA. And I will still add that these charges that you are just referring to, they were not independently investigated under POCA. They were investigated as per the provisions of the Anti-Corruption Act.
Yes. Then he says that in terms of POCA, and particularly Section 83, the Inspector General is not empowered to authorize members of the ACC to investigate POCA-created offences.
That's correct.
And therefore he says that the ACC's investigations into the money laundering and racketeering charges is unlawful.
It was not unlawful.
Okay. And I just want again, and Mr. Kanyangela, I want to place on record, it is not my contention that if you make the concession, the prosecutor is bound by it. But I just want to understand so that I can give it further thought. Your contention is that the power of the ACC to investigate money laundering and racketeering charges derives not from POCA, but from the ACC, from the Anti-Corruption Act, sorry. Is that your contention?
Yes, that is my contention.
Yes. Okay, you know I disagree with it, but that's just, but at least we know where we stand as against each other. And therefore, Mr. Shangalala says the institution of these charges is unlawful. It's obviously something you disagree with.
Yeah, I disagree with it.
Okay. Now, can I ask you, please, to look at paragraphs 24 and 25 of his affidavit? Now, Mr. Shangala says that this court is not the appropriate court to make a decision because no decision, the validity of that decision is not a matter that this court needs to decide upon. That's a legal issue, but I'm just placing it in context. And then at paragraph 25, he says that for the purposes of the bail application, the issue is a factor that His Lordship must take into account, because if His Lordship finds that there is a reasonable case for that contention, then he can take into account that perhaps the POCA-created offences are not charges that the accused are properly facing. And that's the purpose this matter has been raised at such length in these proceedings. So I'm just explaining to you that's what Mr. Shangala says. You want to comment on that?
We can leave it to the court to pronounce itself on this matter.
Yes. No, you're quite right. But I intend going on to a new topic. We have a 10-minute...
It's 11:35. We take a break until 10 to 12.
Esmeralda, please.
Court will rise.